Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will talk about the case of State of Haryana versus Rajkumar alias Bittu, wherein the Honorable Supreme Court discussed the scope of powers of the governor to grant pardon and remit sentences. In this regard, the relevant provision of law is Article 161 of the Constitution of India that reads as follows. The governor of a state shall have the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend or remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. In order to understand Article 161, let us also go through the pertinent observations by the court in this regard. Firstly, the court observed that statutory provisions under the Code of Criminal Procedure that deal with remissions and suspension of sentences are separate from Article 161 of the Constitution of India, and such statutory provisions cannot affect a constitutional power. Secondly, the court cautioned that the power of clemency or pardon is to be exercised carefully, and such power was never intended to be used in an unbridled manner, as it is a power which the sovereign exercises against its own judicial mandate. The act of remission of the state does not undo what has been done judicially. The punishment awarded through a judgment is not overruled, but the convict gets benefit of a liberalized policy of a state pardon. Thirdly, the court also noted that the constitutional power is untouchable and unapproachable and cannot suffer the vicissitudes of simple legislative processes. However, the court also explained that the governor is bound by the advice of the state government, and the governor is but a shorthand expression for the state government. Therefore, in reality, the power under Article 161 is utilized by the state government and not the governor. Fourthly, the court cited the case of Maru Ram versus Union of India, wherein it was held that the power to remit is a constitutional power, and any legislation must fail which seeks to curtail its scope and emasculate its mechanics. And the exercise of this plenary power cannot be left to the fancy, frolic, or frown of government, but must embrace reason, relevance, and reformation as all public power in a republic must. Fifthly, according to the court, when a state government frames a policy, it can adopt a composite approach and frame a common policy that encompasses both situations under Article 161 of Constitution of India and other statutory provisions. There is no bar that prohibits a state government from framing such a policy. And lastly, the court explained that a right to be considered for remission, keeping in view the constitutional safeguards of a convict under Article 20 and 21 of Constitution of India, must be held to be a legal one. This was all about Article 161. The statutory provisions dealing with remission and suspension of sentences were also dealt with in this case, and we shall discuss them in a subsequent post. I hope that the nature and the scope of power under Article 161 of the Constitution of India is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. If you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.